I'm standing rather than Ms Gallagher simply to make a short timing point, if I may. I've discussed timing with Ms Gallagher, and she indicated before the short adjournment that she may in fact be done so quickly that we could be finished today. I, however, would very much like to take overnight to prepare my submissions in reply. And so, unless that puts the court to too much trouble, even were she to finish in time for me to get on my feet today, I would ask for that indulgence.
Well, that's very unusual, Miss Wakefield.
It is, my lady.
Counsel
but
are usually prepared to reply, whatever the timing.
They are. Several new documents have been handed up. I need to consider those, read them in detail. There have been other points that were raised in the course of my submissions, which I'd like to deal with. I can only apologise and say that I would ask to be given overnight, if at all possible. Praying in aid, yet again, my late instruction, if nothing else will do.
Oh, yes, indeed. Well, let us see how we get on, and whether Miss Gallagher does indeed finish, and how much time she leaves you if she does finish today, and then we will see what we can do.
Grateful, thank you.
My ladies, my lords, I'm going to continue on the topic 1, the jurisdiction, remit and role of the Court of the Seneschal points, which I was dealing with before the break. I want to take you to 2 items which are prior to April 1583, because the appellant submissions have picked up the story in April 1583, save for the very brief summary that's been provided in their written case about what happened prior to that. And there's 2 items I want to go to. One of them is the Berkeley case, which I'll take you to in a moment. And the second is just a very short document, not controversial, but I thought it may be of assistance, particularly to my Lord Wilson, who'd asked for some assistance in relation to Alderney and what the position was in Alderney. So this is an item, just make sure we can provide it to you. It's a 1309 document, and this is a short extract from it. Thank you.
Thank you.
Thank you.
Thank you.
So there's 2 parts to this. The first is just the preface, and then there's page 29 onwards, and every second page is in English. There's a translation combined with the original from the Assizes rolls. The sole reason that we provide this is as more context. We thought it was useful overnight in light of the question which my Lord Wilson raised about the phrase in the April 1583 order relating to as it is in Alderney, because this provides, if you look at the index, which is on the second page, you'll see that it summarises the position with the King's letters patent to justices and so on, and then in the document itself it then runs through common pleas in Guernsey, pleas in Sark, and so on. So the short extract we've provided is just for 2 purposes. The first is, if you look under the heading Preface, so on the second page, in the 3rd paragraph down, under a brief account of the nature of the assizes held in the islands by the justices itinerant will not be out of place, you'll see that there's a description there of how the institution of the assizes is anterior to the separation of the islands from Normandy. They were to be held at intervals of 3 years, and a description is given there. And there's a description then about what happened, there being a dispute about the role of those courts. Could you just give me a moment? So sorry, I'm using a non-marked up copy just by accident. I'm sorry about the mistake. So the preface is worth reading in your own time. I'd ask you to turn up page 29. And do you see under continuation of the pleas before the said justices, the said day and year, Guernsey on the left, it's down the bottom of the page, it says the commonality of this island being asked what law they use and by what law they claim to be governed, i.e. whether by the law of England or of Normandy or by special customs granted to them by the kings, they say neither by the law of England nor of Normandy, but by certain customs used in this island from time immemorial. And ultimately, as the document shows, that position was accepted. And I provide that because it's part of the context when we then turn to the Berkeley case. Berkeley number 2 is in Authorities Bundle 4, tab 51. It's MS page 2135 is where it starts. And I just want to take you to a very short passage at page 2142 and 2143. It's paragraphs 8 to 10. And so paragraph 8 just describes the status of the bailiwick and of Sark. And then paragraph 9 summarises the history from the Norman conquest of England in 1066. And you'll see reference halfway down that paragraph, just by the letter G, to the Treaty of Calais of 1360, containing a clause confirming that the King of England shall have and hold all the islands which he now holds. And the reason I provided that 1309 document is to show the reference by that time, when you have the Treaty of Calais of 1360, to the islands describing having their courts and having customs from time immemorial. In paragraph 10, reference is then made to the charter granted by Queen Elizabeth I to the people of Guernsey, Alderney and Sark in 1560. Unfortunately, that is not in the bundles, but it is relevant, and it's relevant solely because of this particular extract. So rather than trouble you with further papers, unless you would like a copy, we're relying on what is said in paragraph 10, which we don't consider to be controversial. So it granted to the bailiff and jurats and all other magistrates and officers of justice full and absolute authority, power and faculty to have the cognizance, jurisdiction and judgment concerning and touching all sorts of pleas, processes, lawsuits, actions, quarrels and causes arising within the islands and maritime places aforesaid. So the broadest possible language, all and all sorts of those matters. And there's then clause 6 provided also. But the key part for us is the start of that extract at paragraph 10. When we then turn to the 1583 order, the April 1583 order, which you've been taken to a number of times, I'll just turn it up very briefly, because you've been taken to most of the relevant provisions. That's at volume 1, tab 1, MS 790. The context is, in 1560, this charter having been granted. And if you look at MS 790, and the third article, these jurats to hold pleas and use jurisdiction in Sark in all causes, as is used in Alderney, and appeals likewise to be from Sark to Guernsey as to the superior justice in all causes, as is used in Alderney. Again, the broadest possible language, in all causes being used twice there. And our submission is that my learned friend's submission was correct to the extent that she said the purpose of this was, as the Court of Appeal rightly said, to deal with the fact that the inhabitants of Sark had started in their court, which had previously existed under the bailiwick of Guernsey, to apply Jersey law. And the reference to Alderney is, you, like Alderney, are another island as part of the bailiwick of Guernsey, and you are to apply Guernsey law, as in Alderney. And we get some further assistance in relation to that from Article 15, which you've been taken to already, which refers to the inhabitants observing the ancient laws and customs confirmed to be established by Her Majesty as in Alderney. And that links in with the Charter of 1560 and the earlier documents referred to. in the Barclay case and in the document I've just provided to you. But there is one other piece which is useful. If you look further down this page, MS page 791, I'm afraid the text is very small, so I hope I can assist you with finding it. It's 5 lines up from the bottom, above the heading Premiere. We do have a translation of this entire passage. It starts with 5730, but I don't need to take you to all of that. I just wanted to draw to your attention the reference to Sark being annexed to the island of Guernsey at a time when memory of the country does not exist. And I'm reliably informed that that is different to time immemorial. It's something even more strong, that language, than time immemorial.
So, sorry, where are we looking at?
So can you see 5730?
Yes.
And if you look, it's 5 lines up from the bottom. There's a reference to annexé ton mémoire n'existe du contraire. So it actually says, the passage says...
It's 6 lines up from the bottom.
I'm so sorry. I thought my difficulty was going to be Old French rather than counting. So my apologies for that. And there is also over the page an extract which is translated in the case, which again refers to loi et coutume in administering justice. But the key point here is Article 3rd, the third article, referring to in all causes, and the language referring to as is used in Alderney simply cannot bear the weight that the appellant is attempting to place upon it. So the appellant is attempting to say that when you read these provisions, what it means is that a decision had been taken to, in essence, punish the inhabitants of Sark and treat them differently to the remainder of the bailiwick because of what had happened with Jersey law. And thus, from this point onwards, April 1583, they were to apply customary law of Alderney as it stood at that point, preserved in aspect at that point, and they were to be treated very differently to the remainder of the bailiwick. And it's simply not possible to read this document as a whole in that way. It's quite clear in this document that the approach that's being adopted is that the bailiwick as a whole is being treated in a unitary fashion.
But what about the reference in Article 15 to be established by Her Majesty? Is that not a reference to the forthcoming approbation?
That's precisely what I was going to come to, because one part of the jigsaw which you haven't been taken to, unless I've missed it, is the October 1583 order in council, and that's quite important as part of the picture, because this was made at a time when that was being developed, the approbation was being developed, and a number of months later, you then have the October order. Now, that's dealt with in a number of places. It may be simplest to take you to it in translation, and then I'll give you the reference for the original document. Could you look at Authorities Bundle 5, tab 67, and the MS page number is 2396. Can I also give you the original reference? But I'd like to work from this one just for the moment with the translation. I think it'll be easier.
Sorry, 2316.
2396.
2396.
So this is an extract from Ogier. I think my Lord Hodge referred to it earlier for a different reason. So in this, at page 2396, can you see just before the indented quotation, the result was submitted to the Privy Council, which on 27th October 1583 ratified and approved the laws and customs therein contained, saving always to Her Majesty and to her heirs and successors power to add, diminish, and correct them at our good pleasure, reserving likewise all other privileges, profits, rights, and prerogatives belonging to her said Majesty, her heirs and successors, nevertheless without causing any prejudice to the ancient and legitimate privileges heretofore granted to the inhabitants of the said island. And that reference to the ancient and legitimate privileges must include, non-exclusively, the charter granted by Queen Elizabeth I in 1560 to the people of Guernsey, Alderney and Sark, referred to at paragraph 10 of the Berkeley case by Lady Hale, which refers to the bailiff and jurats and all other magistrates and officers of justice having full and absolute authority, and refers to all sorts of pleas, processes and so on. So that's the proper context in which the April 1583 order in council must be seen. It was doing a very specific thing at a very specific time, and it's followed a number of months later by the 1583 order in council and the approbation. I don't ask you to turn it up, but can I give you the reference for where the original document, well, it's not in fact the original document, but an older version of this in the original French appears, and that is at Authorities 1, Authorities Bundle 1, Tab 2, and it's MS 803. There is another just brief point in relation to this, which I should have said in answer to a question, I think, from my Lord Wilson before lunch, which is, as described by Blackstone, the reduction of common or customary law into documents approved by the monarch was nothing new at this time. So, for example, King Alfred's Dome Book, and it was never understood as extinguishing common law. So this is a radical proposal that's being advanced by the appellant, and all the more radical when it's not supported by any judicial, extrajudicial, academic texts.
So where do we find the Blackstone reference?
I'm afraid that's a reference which we came up with in response to a question. We can provide it if it would be useful.
Well, just a reference.
It's not in the papers, but we can give it to you. We do have it, if that would be of assistance.
So what was the point of the approbation?
So the approbation was essentially a means of summarising what was understood to be customary law as it was applied at the time. And that's an uncontroversial point, we think, and it's how it's referred to when you look at the academic texts, including Dawes, and we've given you more extracts from Dawes rather than just what you were provided with in the bundle. Could I then ask you to turn, it may be fastest to do this with reference to our printed case, because I've just got a number of points which have the references in the printed case, and if it's convenient, I'd like to do that. And now, I don't intend to go, unless I can assist you, to the 1675 document, which I don't think it's controversial, that we don't think that constitutes a new court. It's a continuation of the existing court. I didn't understand that to be controversial, but if I can be of assistance, please do let me know. I wanted to jump straight to what I will call modern constitutional instruments relating to Sark, which are wholly consistent with the constitution of the court as one of full and broad jurisdiction, and with that language that we see in the April 1583 order, or in the 1560, in the 1560 document, very broadly phrased, and they lend no weight whatsoever to the appellant's case. So starting with the 1922 order. So the 1922 order in council recalls the wording from the 1583 documents referring to all causes. And Article 13 again refers to the Court of the Seneschal being the sole court of justice in Sark. I don't ask you to turn it up, but if anyone does want to, I can give you the reference. It's at Authorities Bundle 1, Tab 5, starting at 828. So the 1922 order mirrors in its language the 1583 order. And there is the provision for an ordinance to be made addressing the jurisdiction of the Sark Court. And there was an exchange yesterday with my Lord Wilson about what that meant, and if that meant that there was going to be a conferring of jurisdiction on the Sark Court by the Royal Court of Guernsey, or whether it was describing something different. And our position is that it's describing something different. And it is not the case that this was a blank sheet of paper in 1922 and that Article 13 took away a pre-existing court which had long established jurisdiction, very clearly set out since 1583, but also acknowledged in the 1560 document, and operating for many centuries prior to that. And indeed, it would be surprising if that were the case, given that the ordinance wasn't in fact made till 1931. I don't think there's any sensible suggestion that the court didn't have jurisdiction between 1922 and 1931. In 1931, the ordinance was then made, and that's at Authorities tab 1, Authorities Bundle 1, tab 7. And this is where my learned friend rests a large part of her case. It's paragraph 1, so it's Authorities 1, tab 7, and it's MS page 850. And paragraph 1 determines the jurisdiction of the Sark Court to be in all matters of movables and immovables, providing always that there's a right of appeal to the Royal Court in Guernsey. And in our submission, that in its opening paragraph maintains the jurisdiction of the Sark Court. It is jurisdiction in all civil matters, whether movable or immovable, with a right of appeal. Now, the argument which is advanced against us is that 1931 ordinance transformed the Sark Court to one which had a very limited jurisdiction, limited to the enforcement of debts. And that's simply not correct. And in summary, there are 4 reasons why that is a very bad point. The first is that there's no reason when you read this to suggest that paragraph 1 was in fact limiting. It doesn't say jurisdiction is limited expressly to movables, movables. It says that the jurisdiction does extend to that. And if you look at the Kellett and Kellett case, which is, I'll give you the reference, it's not necessary to turn it up, that's the illegitimate twins case. That's in Authorities Bundle 6, tab 73, so it's on the supplementary memory stick, page 7. That relates to the guardianship order. That's an example of something which quite possibly falls outside that. And an approach suggesting that paragraph 1 is limiting is obviously entirely at odds with those references I've taken you to earlier, before lunch, including the Dawes text, on it having unlimited jurisdiction. The second point, however, is that in any event, movables cannot sensibly be restricted in the manner that the appellant suggests. The 1852 order defines movables, you were taken to it, as including obligations and actions which have as their object enforceable sums or movables. A claim for maintenance is an enforceable sum. And without us wishing to be facetious, what must go to the Royal Court? Unenforceable sums. It just isn't a sensible approach to take. We do think it's also extremely difficult for them to say it's not an enforceable sum because rather than being fixed, it's arrived at after an exercise of judgment by the court. And that would restrict the jurisdiction of the Sark Court to anything other than fixed or tariff-based sums. So to give an example, tort law arose earlier. It would mean that it would exclude general damages from the jurisdiction of the Sark Court. And it's not properly described as a discretionary assessment. The respondent had a right or an action in maintenance. It's enforceable, and it doesn't cease to be enforceable simply because there is an element of judgment to be exercised. The third point to raise in relation to this is that if the Royal Court had indeed wished to reserve some civil matters to itself in the 1931 ordinance, it would surely have crafted a positive provision. It's very difficult to read that provision in the 1931 order as suggesting the radical change that's been outlined. There's no positive provision describing the particular matters that could only be brought before the Royal Court. There's simply this very broad paragraph 1 asserting that the Sark Court has jurisdiction over all movables and immovables. And finally, fourth point, there's no reason at all why the Royal Court would wish to transform the jurisdiction of the Sark Court, and nothing before the Judicial Committee to suggest that it did. There's no comment, study, analysis of what would be a very radical position. And that is, we say, because there was in substance no change to the civil jurisdiction of the Sark Court. The next point related to this, which has been raised, is that the Sark Court must be restricted because the Sark Court doesn't have ability to decide cases in a range of areas. And two examples are repeatedly given. They're given as if they're two of a long list, but in fact, they're the two examples which are repeatedly given in the papers and were given in oral submissions. And they're judicial review and divorce. So firstly, on judicial review, the point is simply wrong. And we've given you the extract from the Dawes case, from the Dawes book on judicial review, which makes clear that judicial review, I don't have to turn it up now, but it makes clear that judicial review in Guernsey is a relatively new innovation. It's in fact a case taken by Mr. Barnes, who sits behind me. And we do have copies of that case if it needs to be made available. But it has solely been used in Guernsey in this very recent case, and there is no proper basis for suggesting a judicial review couldn't be brought in Sark. No basis whatsoever. In relation to divorce, the position is a little different. So it is correct that in relation to divorce law in Guernsey is different to divorce law on the island of Sark. And for those of you who do want to go to it, there's some detail at page 93 of the Dawes book. But there's nothing from that, from Sark not legislating to provide for divorce in the Seneschal of the Sark, to suggest that a court which otherwise appears to have unlimited jurisdiction is in fact reduced to this shell of a court which can only enforce debts, and then only debts which are ascertained in advance and don't require the exercise of judgment.
Probably.
Next issue I just wanted to turn to on the issue of, under topic 1, is parens patriae. I'm going to take this quite shortly, and I hope that doesn't cause my lords and my ladies any difficulty. And please do ask me to slow down if this is too quick. The reason I'm taking it quite quickly is simply because we say this is a red herring. It's not, in fact, something that you need to decide in order to decide this case in our favour. But the question that was posed yesterday was, does the Sark Court have a parens patriae jurisdiction? So the English High Court, England and Wales High Court, does exercise such a jurisdiction as the delegate of the sovereign to exercise the sovereign's protective role in relation to children who are their subjects. And in our submission, it's not as simple when you turn to the Sark Court as saying, well, a request for a royal seal was made in 1583 and refused, because it's perfectly evident that courts of Guernsey, Alderney and Sark are royal courts. So I've taken you to paragraphs 9 and 10 of the Berkeley case, and in particular the Royal Charter of 1560, which refers to full and absolute authority and power. And there's a few further references which support that. As to royal charters, it's also worth looking at Ogier, Authorities 5, tab 67, MS 2396. Again, I don't ask you to turn it up. And also the Order of April 1583, the demands of Sir Thomas on behalf of the Queen's Majesty. And that, consistent with the Royal Charter of 1560, gives jurisdiction in all causes. And it will be seen in Ogier at MS 2392, a few pages earlier, that as early as King Edward I sent a seal of his own to the Channel Islands for the use in their court. So we say that, in fact, Sark is a royal court, just as the Court of Guernsey is. Its power and authority is granted to it by Her Majesty, and that's the history. There must be a court responsible for discharging the Queen's prerogative on Sark. Not obvious why that would be limited to the Guernsey court. And it's consistent with it being a court of unlimited civil jurisdiction. Now, that jurisdiction is not a movable or immovable jurisdiction. And we accept it's necessary to consider whether paragraph 1 of the 1931 ordinance was intended so to limit the court's jurisdiction. And our submission, for the reasons we've given before, is that that is not the case. The intention appears to have been to preserve and continue the Sark Court's jurisdiction rather than limit it. So I've made those submissions briefly because we don't think, in fact, you need to go there in order to decide this case. What we do ask you to do in order to decide this case is to look at the Court of Appeal's very succinct way of dealing with this matter. That's paragraphs 41 to 45 in their judgment, which I referred to earlier. So that is... It's in volume 2 of the record, MS 741 to 742. In our submission, the summary which is provided there is entirely accurate. And in fact, there's more material which supports it. But our submission is that paragraphs 41 to 45 accurately state the position. They accurately summarise the effect of the 1583 order in council. They dispute and disagree with the father's contention that the law set out in the approbation could only be changed by legislation, albeit that that's a position where he had a different approach in relation to Sark on the one hand, Alderney and Guernsey on the other. The customary law, like the common law of England and Wales, is capable of development to adapt to changing circumstances. And he rightly supported the finding of the deputy bailiff in relation to Morton and Paint, the 1996 case. I won't take you to it, because that simply can't be explained on any other basis. And you'll have seen in our case that we support that. So the question then turns to whether material exists from which it can be determined that the customary law of Sark has developed to allow the Court of the Seneschal to award maintenance for children, in particular in this case for illegitimate children. Now, just before lunch, I took you to recent legislation which suggests there is such a jurisdiction, clearly established in the 1984 provision, and customary law being referred to yet again in the 2016 law. The two items which were highlighted in particular by the Court of Appeal were, first of all, the 1868 law, and then, secondly, to one individual case. So in relation to the 1868 law, it was conceded in the appellant's case that this applied to Sark. Today, for the first time, it has been put to you and put to us that it's doubtful whether that applies to Sark. And this is another example in our submission of an extremely unhelpful technical approach. And if I may use the phrase, a back of a fag packet approach to something as serious as this, half a decade into these proceedings. It is not acceptable to come before the Judicial Committee of the Privy Council and to say, in relation to a law like this, the 1868 law, without any proper basis, well, we can't see a passage which refers to it having gone to Sark in the way you might expect. So we're going to run a point that it doesn't in fact apply to Sark. There's no proper basis for that when you look at it. It's described as applying to the bailiwick of Guernsey, and Mr. Richards was quite right to have accepted in his written case that it applied across the bailiwick, and it did apply to Sark. And the Court of Appeal was quite right so to find also. But even if you're not convinced on that, and even if you think there may be some doubt, there is more than sufficient material in the documents provided to you before lunch, in the case which is referred to here at paragraph 44, and precisely whether it was a tort case or a maintenance case properly put, to adopt the language of my Lord Hodge yesterday, doesn't really matter a jot, because it shows that there's a provision in a closely analogous case, if not precisely in a maintenance type case, to award a maintenance type award. And then we've also provided you with the authorities in Authorities Volume 6, which show a range of other cases. So I don't ask you to turn those up. I can confirm, wish to rely on Mr. Barnes's statement. We very much heard what the Judicial Committee said yesterday about evidence, but we do rely on the cases. So there are 3 cases provided in the bundle. There's the 2007 case of Williams and Martin, Authorities Bundle 6, tab 76, it's supplementary MS, page 11. And that shows that the action is actionable by the creditor or the parent. That's an unmarried case. And then there's two married cases. There's the case of Maunder. I'll just give you the reference. Authorities Bundle 6, tab 72, supplementary MS 6. Now, although parts of that are in French, the actual order is in English in relation to maintenance. And then Bonifat, Authorities Bundle 6, tab 74, supplementary MS, page 8, and that's also a married case. So there are a range of cases there which show that.
What is the name of the applicant in 672? Monsieur Thomas, line 3. Godfrey?
We have obtained for our own purposes a translation.
It's just the name of the claimant, really. It's
so Maunder in 72.
tab 7, Maunder, you say?
Yes.
Okay. I'll find his name somewhere.
And the relevant part is a supplementary
12 lines down, isn't it?
I'm so sorry, I didn't hear. My Lord
Oh,
Manson
yes,
may
I
have asked
see.
something.
Helen Maunder.
Yeah.
Helen Elizabeth Maunder. Thank you.
It's on page 6,
Yeah.
the order itself, and you can see it more clearly there.
She had the misfortune to marry her husband 2 months before.
Yes.
Yes.
And the date, 1920.
Have you got the
It says in the index that it's 1920.
Yes.
It says at the top, too.
So it does.
It's 22nd of December, this one,
Yes, it is 1920.
about 10 lines down.
Yeah.
Bonifat is 1980.
And the tab 74 one is a 1982 case. So by the time of that 1984 law that I referred you to earlier, section 27.1, you have not only the case that was referred to by the Court of Appeal, you also have this 1982 case, and you have the 1920 case. And I make no submission about how easily they were found, how many other cases there may be. Simply there are cases, they're there, and they're provided to you.
Well, certainly the Seneschal seemed quite content to give interim aliment of 18 shillings to the wife.
That was precisely the point.
Pending the hearing of the action.
Yes, that's precisely the point I was going to come to next. I was going to deal with interim maintenance. I indicated I was going to deal with it very briefly.
Yeah.
And I was going to say,
For
Maunder and
page
Maunder deals with
of
that
the
point.
signatures.
The court awarded interim maintenance, and it's quite clear in our submission that the power thus existed already at common law. That's a 1920 case. And that's paragraph 4 of the order in English on supplementary MS 6, volume 6, tab 72.
Wait a minute, is it 4? I mean, 3 seems to deal with her. Are they dealing with one case or several cases here?
So if you see at 4, it says
I mean,
the sum of 18 shillings to be paid by the husband
To Mrs. Baker?
for maintenance of the wife
Oh, to
pending
Mrs.
hearing of the action.
This is a different, there seem to be different people, you see.
Yeah.
But paragraph 2 deals with costs to be paid by John Hatton. Paragraph 3 is Maunder, granted maintenance of 5 shillings British a week to be paid by the husband. And paragraph 4 is someone else, I think. It's rather curious.
We have a translation which suggests that that relates to the same case.
Oh, no, perhaps you're right, yes, because at the first line it says John Hutton is condemned to pay towards Helen Elizabeth Maunder.
Yes, that's at the top of the page.
On the action of the Ladite Maunder. Okay. Where's the translation?
We can provide it. We were conscious of the practice direction in relation to foreign languages and having a statement and so on, but we're conscious
not
that
a foreign
French is
language
obviously...
in this court, is it?
Well, no, we were conscious of that. But we didn't want to assume that all lords and ladies of the Judicial Committee of the Privy Council are familiar with Norman French, so we can certainly provide the translation if it will be of assistance. We did also attempt to obtain a translation when we received the extracts last week from the approbation and so on. We did, and it simply wasn't possible to do it in the time. and we apologise for that. They're not documents we asked to put before you, but we apologise that you've received them in that form. If you would be assisted
I think the answer is
by these
she's
translations, we can provide them.
I'm sorry to interrupt. I think the answer is she became Mrs. Maunder Hutton, didn't she? She married Mr. John Hutton. If you look at 3, it says Helen Elizabeth Maunder Hutton. Granted.
Yes, yes.
Yeah.
Granted maintenance of yes.
But what the reference to Mrs. Bartha and
Well, it does say for maintenance of the wife, and
yeah.
it may just be a third party who is being provided with it for another reason. I can't say on the face of the document. The key point is that it's an interim award pending the hearing of the action. Under customary or common law, and it plainly existed at that time.
Mm-hmm.
There has been a point made that Sark had 400 years to change the law, and why didn't it change its law when other islands did? The primary position that we adopt is the action for maintenance has existed in any event in common law, as indeed it did in Alderney, and as indeed it did in Guernsey. And there is nothing inconsistent with having an action for maintenance at common law and taking a view that that should, at a later stage, be reduced to statute. And indeed, the language that I took you to before lunch acknowledges that those two versions exist, because it gives the presumption that you should use the statute from there on in, unless it's a situation where it would be unfair so to do so.
Can you say when the right to get an order for maintenance for a wife or a child, marital or non-marital, came in, or is that an unfair question, Ms. Gallagher?
I think very difficult to say, and again, it's not an issue which you must determine for these purposes, but it's quite clear that from the 19th century it exists. It's quite clear from the legislation from 1868, and you then have the series of other cases.
Yeah.
But in any event, our submission is that it was always possible for this to be developed and applied.
But even if there was doubt about the 1868 law's application, do you also pray in aid section 27(1) of the 1984 order?
Yes, we do.
Because that is an explicit recognition of a customary law of Sark applicable to maintenance orders.
Yes, we do. I've taken it out of order just for housekeeping reasons. I thought it would be more helpful to give you those documents over lunch. So I realise I've gone to the more recent documents first and then reverted.
Yeah.
But I thought that may save some time also when it came to returning to the 1583 documents.
But
Because the position is
it's potentially quite a powerful point if the legislature has stated that maintenance orders in respect of a woman in a convention country are to be operated in accordance with Sark's customary law for maintenance.
Yes.
Could I just put to you a theory in relation to the Maunder order?
Yes. I anticipate it will be right. If I was a betting man, we shall see.
Flattery, flattery. Paragraph 1 grants the petition. Paragraph 2 orders basically the husband to pay the cost of the action.
Yeah.
Paragraph 3 grants her maintenance of 5 British shillings a week to be paid by the husband. The sum of 18 shillings is to be paid by the husband to Mr. Baker or Barter or whoever for maintenance of the wife pending hearing of the action. I think that's what Mr. Barker paid the wife to keep her pending the trial that resulted in this order. That makes sense. It's not an interim order, it's a repayment of somebody who actually was discharging the other party, the husband's liabilities.
Ah.
It's quite possible.
It is, isn't
and
it?
I may have put it too
It's
high
quite
to
likely
say,
even, yes.
And I may have put it too high to say that on the face of it, the language refers to interim maintenance.
I think it's probably allowing the chap who'd been maintaining the wife when the husband should have been doing so to recoup the costs of doing so. But that's That's just a theory, and I'm not sure it's going to assist us very much
No.
in deciding
On
this
interim
case.
maintenance, we do deal with that in our written case at paragraph 61 to 64 before we had seen the Maunder case. And we say it's a very bad point in any event. It would be a worse point if Maunder did indeed involve the payment of an interim payment, but I can see there are alternative ways of interpreting that. If the Royal Court or the Sark Court had no power to make an order for maintenance, it would of course follow that it doesn't have a power to make an order on an interim basis. But our submission is that it did have such a power, and it plainly also has a power to make an interim award for maintenance in those circumstances, whether A, as part of the common law action for maintenance, or B, under the court's inherent jurisdiction to regulate its own proceedings. So I use the phrase inherent jurisdiction there in the more limited sense. And as to the former, once it's established that there's an action at common law for maintenance, it's plainly not a great leap for the common law capable of refinement by the courts also to permit an interim award. And as to the latter, for the reasons we've given in paragraph 64 of our written case, the applicant's reliance on a series of authorities was correctly distinguished by the Guernsey Court of Appeal, paragraph 55 of the judgment, and we support that reasoning and we don't seek to add to it. I'm conscious that this was one of the grounds which was indicated I didn't need to go to in detail. So can I just rely on 61 to 64 and the references we've made there? The final issue to raise in relation to this topic, topic one, which is the by far and away the most meaty topic for us, final area to deal with is just a small number of miscellaneous points which arise from the fact that this is also a decision which is being taken after the institution of the human rights law. And the deputy bailiff referred to a modern rights-based society, and that being the effect of the human rights law as it applies in Sark. He referred to it being unconscionable that a parent in Sark would have no remedy before a court in Sark in the circumstances in which the members of the party's family find themselves. And he said, put simply, it offends against my notion of the extent of justice that should be available. And in that context, we just wanted to make three brief points. The first is that the right to maintenance in Sark, which we say is a long-established right, finds a ready parallel in the common law of England and Wales. Blackstone, indeed, regarded it as a principle of natural law, and we've given you the full reference to this at page 19 of our case, paragraph 50.1. And he said it's a principle of law that there is an obligation on every man to provide for those descended from his loins, and the same applied to children born out of wedlock. And the relevant passages there were cited by Lady Hale in the Kehoe case. Don't ask you to turn it up, but it's authority.
Didn't get me anywhere, though, did it?
Tab 37. So the English common law has long recognised a form of obligation akin to this. And the absence of an action of common law was rectified, of course, in the mid-19th century in England and Wales by the 1857 Act, Section 35. And we deal with that in our written case.
Now that slightly reflects the Basnage commentary on Norman law, doesn't it?
Yes, it does.
Which we've got in paragraph 48 in the Royal Court judgment, one of them at 548. Basnage was written 1709, not all that far from when Blackstone was writing his commentaries. And if you've got that to hand, Miss Gallagher.
Yes.
Bearing in mind that custom says nothing about the alimentation of non-marital children, but nevertheless, by an equitable view, one obliges the fathers or their mothers to give them something by way of alimentary pension. They must bring them up until they have the means of earning their own fortune, imitating the other animals who only abandon their little ones when they've been able to find their own pasture.
Yes. Yes, it very much echoes that point.
It does.
The second issue, and I don't go to this in detail in the circumstances, but I just wanted to flag it, is that there are numerous international instruments, including in particular Article 27 of the UN Convention on the Rights of the Child, which requires state parties to take all appropriate measures to secure the recovery of maintenance for the child from the parents or other persons having financial responsibility for the child, both within the state party and from abroad. And the full references for these points are at 50.2 of our written case, page 20. Now, we don't need to go into this in detail for present purposes. The UN Convention on the Rights of the Child doesn't extend to Sark, but Sark is subject to the human rights law, and of course, as is very well established in the sister court, in the Supreme Court cases running from ZH onwards, in which many members of this court were sitting, so ZH, HH, Matheson and so on, it's very well established that when considering the parameters of Article 8, the European Court of Human Rights has regard to international instruments, including the UN Convention on the Rights of the Child, see Neulinger and so on, and it is an interpretive aid when it comes to you applying a domestic provision, and that applies regardless of whether or not the UN CRC applies to Sark. And the third point we make is that against that backdrop, and in these circumstances, an absence of maintenance payments would undoubtedly have infringed the Article 8 rights of my client and of her son. Now, while Article 8 may not give rise to a right as such to receive regular, reasonable maintenance, we're conscious of the Smith and Smith case, which we've provided in the bundles, and we've given you the reference again at page 20 of our written case, and we're also conscious of the M case. Our submission is that Article 8 does impose a positive obligation to take steps which permit the child's integration in his own family, and where the absence or inadequacy of maintenance payments does impact upon family life, for example, because it limits the amount of time a parent is able to spend with the child or prevents a parent from maintaining a family home in which family life could be shared, then there may be a breach of Article 8. We've given you the reference to Logan and the UK, which failed on the facts but established the principle. And that's Authorities Bundle 2, tab 27. And I don't need to go to that now. Our position is that that's all additional. You don't need to be satisfied of any of those additional points to be with us, because the Guernsey Court of Appeal was quite rightly satisfied in that short page that there had long existed a common law an action in maintenance, that the April 1583 order and the approbation of October 1583 did not have the effect contended for by the appellant. There was such a right, and even if that were not the case, given the matters that we've dealt with, we would have been perfectly justified in developing such a right as a matter of common law, and would indeed have been obliged to do so under Section 6 of its human rights law.
You speak of the common law and of the customary law. In this context, are you using them interchangeably?
Yes, so I've taken you to the definition earlier, which referred to common law and customary law, common law and customary law, including the common law, which is now the current usage. There is a long history where they ran in parallel, and they have at certain times been considered very different. But I've taken you to the definition earlier. And in our case, similarly, we referred to customary law and common law. I can take you, if it would be of assistance, although it may be more sensible for me to conclude the remainder of the submissions and return to it, I can take you to a little more learning, if it would be of assistance, on the distinction and how the two streams
if you
diverge.
could submit something in writing to remind me, that would be helpful, unless my colleagues want it to be given orally. But I think we better tie that one down, simply because the definition to which you refer was a definition for the purpose of the particular statute.
Yes. I'm quite happy to do that. I mean, we can reduce it to 2 pages and just give you
That'd be very helpful.
the key references. And it doesn't change, it doesn't alter any submission which we're making.
No.
And that will explain, I hope, why in some places in our case we said common or customary law.
Well, certainly when I sat in the Channel Islands, the terms were used pretty interchangeably.
Yes, yes. So I dealt with issue 2, which we had intended to deal with in substance, but in fact there's no need to do that. That was simply just the point about the remedy being sought and the remedy being wholly inappropriate here. So a re-institution of the order that was made, which has been overturned on appeal, which hasn't then been the subject of appeal. I mean, it's just astonishing to find that there's an application here to have that order restored. So I'll now turn to topic 3. So topic 3 relates to conflict of laws in the courts below and how this was dealt with. Now, our submission on this is that special leave should be refused on this point, and this is not a matter which is properly before this court. Could I ask you first to look at, as context, the Court of Appeal judgment? So again, it's volume 2, towards the back. And it's page 734 in the electronic record. It's paragraph 21. And the Court of Appeal said, in the private judgment, the Deputy Bailiff commented on the fact that the father's notice of appeal against the March 2015 order contained 47 separate paragraphs, and the notice of appeal against the July 2015 order contained 78 paragraphs. He said he'd struggled at times to understand exactly what it was the father was complaining about and how it possibly affected the lawfulness of the two decisions. This message was plainly lost on the father, since his notice of appeal to this court contained no fewer than 242 paragraphs, each advanced as a separate ground of appeal. So I would count yourselves lucky that you've only got 7 grounds of appeal, given that the Court of Appeal had 242 to contend with. This is unacceptable from any litigant for the reason that's given there. And that is the basis on which the Court of Appeal then said, can you identify the 10 key issues that you need us to deal with? What needs to be resolved? And they then say, we've based our consideration of the father's case on the document he produced in response to this invitation and on his oral submissions to us. These embrace the core of his complaints about the disposition of his appeals to the Royal Court. They refer then to further documents being received thereafter. You'll see then the 10 questions, which actually are longer than paragraphs 41 to 45, the key passages I took you to earlier, with very many sub-questions. Many of them go from A to G, A to F, and so on. So in this very long list, you will see, as question 4, which law should be applied by the Sark Court to the application of the mother dated 28th of January 2013, Sark law or the law of domicile. And then there's 2 alternatives given. It's not even a submission being made at that stage as to what the law of domicile was in this question.
Well, that's fair enough. I mean, is it not? Because it's just posing a question. You can't expect a submission to be included within the question.
Of course. Well, I'm going to take you to why this simply isn't a point that was properly pursued. Now, the applicant did argue, as a matter of fact, the parties were not habitually resident on Sark and that the Sark Court didn't have jurisdiction. And that was rejected by the Sark Court on 30th of May 2013. Indeed, I think a question came from the panel earlier in relation to that. I don't ask you to turn it up, but that's at Record Volume 1, page 126. Now, the applicant did also, or the appellant, did also argue that the legitimacy of the child should be determined with reference to German law. And that matter was resolved by the Sark Court in its judgment of 12th of September 2014. That's at Record Volume 2, page 434. And as you know, the court considered, having heard evidence, that the status of the child under German law was not that of a legitimate child. That's not a matter before this court. It was not argued before the Sark Court that if it did have jurisdiction, the correct choice of law was other than that which applied to Sark. And there's an air of unreality to the submission which was made earlier about why that point wasn't raised in circumstances where choice of law was being run in relation to legitimacy of the child. And I think my Lord Hodge asked a question on that point. But in any event, it could have come before the Court of Appeal properly, even had it not been raised previously. There are circumstances in which that may be acceptable. This is not one of them. The appellant's grounds of appeal against the Sark Court are at Volume 2 of the record, page 489. And the closest that he comes to pleading the point is ground 20. And you'll find ground 20 at MS 495, where he refers to the judge erring and not considering it an abusive process and didn't consider the applicability of law which would give an amount which was significantly lower. So that's the way in which it arises. Now, it's not clear from that whether it was intended to be a jurisdiction or a choice of law point. And in any event, the argument now being advanced is that the applicable law, as we understand it, is that of Germany. So quite a different point.
Appears to be a discretion point, doesn't it, really?
Yes, it does appear to be a discretion point. I'm so sorry. I have a slight hearing issue, and I'm sorry, I'm sometimes finding it a little difficult to hear the questions. So my apologies. And if there's difficulty in hearing, I will say it again. So I'm very grateful to Mr. Jacobs for telling me what was said. We agree. It does appear to be a discretion point. Now, the Deputy Bailiff of the Royal Court complained about the 78 grounds of appeal, confined his consideration to the grounds of appeal actually pleaded and the way in which they've been developed by the appellant in his written and oral submissions. And that's at paragraph 28 of the private judgment. Just the reference for your note is volume 2, 542. Now, he doesn't directly address ground 20 to the extent that it is a ground, other than to confirm he's given consideration to all grounds and rejected them. Now, the grounds of appeal against the Royal Court are then found at page 591 of this same volume. And you have to go all the way to ground of appeal 212 to find something on point. And 212 is at page 621. So that states, the judge erred in not considering or following the law of the domicile of the child in family matters or in action relating to movables. And of course, he now says it's the domicile of the respondent. Quite a different point again. And in any event, that point, ground of appeal 212, was not elaborated on at all before the Royal Court. Unless we've missed it, and we have all been through it, the transcript of the proceedings is at volume 2, page 628. And the appellant did set out at page 635 that one of the questions to be considered was question 4, but it wasn't otherwise pursued by the appellant in his oral submissions. At page 662E, there's reference to legitimacy deriving from the law of domicile. Pages 664 to 665 deal with jurisdiction. He simply didn't pursue this in argument at all, other than listing it as an issue, and indeed listing it as a question, as my Lord Hodge says, an open question, not even saying what the submission is about what the proper jurisdiction would be, or indeed why. So it's not surprising to then be in a position to see the Court of Appeal simply stating, as it does at paragraph 24 of its judgment, that question 4 raised an issue on which the Seneschal had decided made no difference to the outcome, which is now criticised by my learned friend.
Well, rightly criticised.
Yes, the description that's given there.
Criticised by the Seneschal, rightly criticised.
Oh, I'm so sorry. I thought you meant rightly criticised by my learned friend. So we say this was rightly criticised by the Seneschal and then rightly criticised by the Court of Appeal, this approach, and simply including in that long list of questions, including ground of appeal 212 in the format that they did, and then including question 4 in the format that they did and not pursuing it in oral argument other than saying it's there, that's not an acceptable basis upon which to come to the Judicial Committee of the Privy Council, a final Court of Appeal, in a case which is an appeal as of right case. And this is precisely why yesterday we said, even if you take the view that the low threshold, and we accept it may be a low threshold on the cases, if it is a low threshold, even if you take the view contrary to our primary position, that special leave should be refused in respect of this case as a whole, our submission is that it certainly should be refused in respect of this ground of appeal.
I don't think I made my intervention very clear. Didn't the Court of Appeal get muddled in saying that the choice of law point had been knocked out at an earlier stage.
Yes,
it was a different choice of law point.
Yes, so this is the point which my learned friend made earlier.
Yes.
So they did say in the paragraph that you were taken to earlier that the lower court had dealt with this issue. Now that's
Yes.
because the lower court had dealt with the issue of legitimacy.
Quite, yes.
But our point is that there simply wasn't another point to be determined in the circumstances. So even if that phrasing in that particular paragraph didn't reflect the fact that question 4 or appeal ground 212 may potentially have raised an additional issue, it's not an issue which was pursued in oral argument. And the paragraph I've taken you to, where the Court of Appeal explained the context, where it said, we've been faced with this barrage of grounds of appeal, having had the appellant being told over 70 grounds in this way is not helpful, to then produce over 200 is even less helpful. It is not surprising that the Court of Appeal then said, we are going to focus on the matters you have given us as the 10 key points, and within those to focus on the ones you've pursued in oral argument. And it is wholly unsatisfactory for the Judicial Committee to be expected to deal with this essentially as a first instance court, with no evidence before it, and where even looking at question 4, you can see how loosely it's phrased. Refers to 2 possible other jurisdictions. It's a question, as Lord Hodge said. It's not a submission. And neither was ground 212 a submission. And it's now being dealt with very differently. And we don't take a technical point. We very much agree with the reasoning of the Court of Appeal in not taking technical points. And that's precisely why yesterday we thought you may just want to deal with this in a rolled-up way. And we said that in our written case. But it is not an acceptable position for my client to be placed in 5 years into this litigation, to have to deal with a point on the hoof like this. And it's not an acceptable position for the Judicial Committee of the Privy Council to be in. The appellant is seeking to raise an argument which was not pursued at any of the courts below. He accepts it was not pursued at first instance. He phrases it in his grounds of appeal as follows. He says, at volume 2, of the record, page 772, paragraph 41, the board should note that the issue of the law applicable to the maintenance claim was not clearly identified by the applicant until the proceedings reached the Court of Appeal. Well, that concession is right. We say it also wasn't clearly identified in the Court of Appeal. And this is not properly an appeal point. And that's why we've said, adopting the language that was used by my learned friend yesterday, this is precisely the kind of situation in which your appeal as of right should not apply, because your appeal as of right is an appeal from the judgment of the Court of Appeal of Guernsey. And this is an appeal on a wholly different point, which wasn't pursued. Now, it was listed as an issue, but not raised or argued. Now, our fallback position in any event is that the applicable law is the law of Sark. We similarly had a range of questions to those that were raised by the Judicial Committee this morning on a range of topics, but we think it's very unhelpful to deal with this in a first instance type way and without you having evidence before you in relation to domicile or other matters. So unless the Judicial Committee would like me to make further submissions, our submission is that we shouldn't have to on this issue and that we shouldn't have to go into this issue in a first instance way at this level. It's not appropriate. Can I take it that I can move on to the final topic? And I think I can do
I've got
this.
silence from my colleagues, and I think
I'm assuming
interpret
radio
that as
silence means
consent.
I can
Yes.
proceed. I'm very grateful. The final topic then that we can deal with, and we can deal with this very briefly, so I think I will indeed be finished. We worked over lunchtime to try to ensure that we could get finished today, which was the reasoning for rushing through, and I hope you'll appreciate the helter-skelter pace and not taking you to all the references. We're very conscious of your time. So the final issue is about Article 1, Protocol 1, and the quality of law issue. Now, that has been run, and we take no pleading point about it. This has been run before you, not only as an Article 1, Protocol 1 point, but also a quality of law point more generally, including in relation to jurisdiction. And we can deal with those points conveniently, we think, together. So, first of all, Our first submission is that Article 1, Protocol 1 is simply not applicable in these circumstances. Now, you've been provided with JM in answer to the cases which we gave in our written case. I'm just going to give you the cross-references to our written case rather than turn it up. I don't think it's going to be necessary. So we've set out in paragraph 53 of our written case, page 21, why the respondent doesn't accept that the making of a maintenance order involves an interference with the appellant's possessions for the purposes of A1P1, following the view of the House of Lords in the M case. And JM doesn't go to that issue. JM is an Article 14 case about ambit. And as is very well known in a range of cases that have come before Privy Council and the Supreme Court in particular, there are many circumstances in which something may fall within the ambit of Article 8, may fall within the ambit of Article 1, Protocol 1 for Article 14 purposes, but that is a very different thing to engaging Article 1, Protocol 1 and going on to find a breach. So we say they fall at the first hurdle here, and we do also say, yet again, it's rather inconsistent to be adopting the very technical approach the appellant has to mobiles, and then on the other hand to say this is property for the purposes of Article 1, Protocol 1. It's a little surprising. But in any event, we say they fall at that first hurdle. JM doesn't help them. It's an ambit case. It's an Article 14 case. They haven't produced a single case which says this falls within A1P1. So we aren't obliged to satisfy the justification test under A1P1. But if we were obliged to satisfy the justification test under A1P1, our submission is that the parameters of this action were evident from the case law, and in any event, the parameters rely on individual cases. Now, there's a series of questions which are put in the appellant's case. It's at the appellant's case, paragraphs 11 and 12, and some similar points were made orally. It may be helpful just to turn this up. So paragraphs 11 and 12, the appellant's case, say, well, this raises a whole series of other questions. To whom is the obligation owed? By whom is it actionable, for example, at 11.1? And how should it be provided, 11.3? There's very simple answers to each of those questions, very clear from the existing materials. The outline for an action for maintenance would, at the outset of these proceedings, have been perfectly evident from the case of Williams and Martin. That's Authorities Bundle 6, tab 76, Supplementary MS, page 11. It's actionable by a parent against the other in respect of the needs of their child, and it's evident the court would consider the needs of the child and the capacity of each parent and make an award that did justice to the circumstances with the opportunity for both parents. And this whole series of questions, I mean, this isn't a situation where the Judicial Committee has to draft a treatise on a whole range of questions about what the remit of it is. You're being asked to do justice between the parties in this particular case. But in summary, in answer to those questions, 11.1, to whom and by whom is it actionable, may a parent bring in its own right? It's actionable by the parent. That's evident from Williams and Martin. It's also evident from Maunder, Bonifay and Carré, the other cases that I referred to earlier. What are the necessary conditions for it to be actionable is asked at 11.2. Must affiliation or family proceedings be issued first? No, and there's no possible basis for suggesting that. The common law or the customary law has not set out any such requirement. It doesn't exist. And that's not problematic. The Williams case, and we say the Court of Appeal and the courts below in this case, focus on what's important, the needs of the child, the capacity of the parents to support the child. And again, 11.3, how is it to be provided? Is it in money? Again, this is a pointless question. In all of these cases, it's in money. Is it held on trust for the child? It's in money, as is evident from all the cases. And how should quantum and duration of maintenance be assessed? Williams demonstrates it's set with reference to needs of the child, financial resources of the parents, and quite properly so. Now, there were a range of other points made about customary law, suggesting that customary law is inherently uncertain and problematic and at odds with the certainty requirements in Article 1, Protocol 1. That was one of the points made. And then the other point made was, well, the Seneschal's a layman, as if that's a problem per se. So on those 2 points, we say they're both bad points, and they don't assist on the quality of law issue, and I'll finish with these 2 points. So in relation to customary law is respected, and rightly respected, in the Judicial Committee of the Privy Council. Indeed, it's very well respected in a whole series of international instruments, which again, the ECHR has regard to. In the same way, following Neulinger and so on, it has regard to the UN Convention on the Rights of the Child. It could properly have regard to the ILO Convention 169 on indigenous peoples in independent countries, Article 8 of which points out the importance of respecting national laws and regulations and customary law, the UN Declaration on the Rights of Indigenous Peoples, and indeed the Privy Council has referred to the importance of customary law in a range of cases.
Yeah, but what is being said is that this is thoroughly obscure. And
yes.
I'd just like to test one point, because it's occurred to me in other cases. Supposing you do have something which is unsatisfactorily obscure, the court in the particular case may clarify the principles along the lines you've just been suggesting. Supposing they weren't clear enough before, we could state them now, and then for future litigants, it would be absolutely clear, and there'll be no doubt what the law was. It seemed very unfair if the current litigant, claimant, was deprived of the claim simply because it had been unclear until she succeeded in getting the court to clarify it. And it's quite often occurred to me that the better approach in that situation is for the court to clarify the position inter partes. This is private litigation, and if the law has been unclear hitherto and one party has suffered an unexpected financial blow, they can pursue a claim against the government for breach of the Human Rights Act.
Would you like me to answer that question in the abstract or in relation to this case?
Well,
we say this is
why couldn't that be an appropriate approach in this type of situation? Because it would seem extremely unfair to deprive a legitimate claimant of what, as far as she was concerned, might seem entirely a foreseeable claim, even if one concluded that, in fact, as regards the defendant, it wasn't foreseeable.
Could I answer in 2 different ways? Could I answer in theory and then in practice in relation to this case? So in theory, we entirely agree that there may be circumstances in which that's appropriate relief to grant. And indeed, I don't have the reference to hand, but it immediately occurred to me when you were asking the question, the case of Spectrum Plus, we can get the reference for you if you'd like, where it's very possible to craft a creative relief, which is prospective only, for example, to deal with the justice of the case. That's even something which has been done, of course, in criminal cases when the law is changed in a way which may prejudice an individual defendant. So in an individual case, that could be an entirely appropriate way to proceed. And there's a range of other examples by analogy where you may not have a claim against a private body, but you may have a claim against the state under the Human Rights Act, for example. When you were sitting as the Supreme Court, you may have a claim against the government for failing to facilitate you in exercising your right against a private party. So we entirely agree that that could be appropriate in theory in some circumstances. We do not agree that that could possibly be appropriate here. This is a situation in which...
what couldn't be appropriate? We couldn't do anything in these proceedings anyway. If as a result of the outcome of these proceedings, the appellant felt aggrieved, he'd have to commence separate proceedings against the government saying he'd been unfairly prejudiced by having a liability imposed on him. It had been nothing to do with your client.
I'm so sorry. I've misunderstood the question. I thought that you were suggesting that there may be a situation in which my client may not be able to recover against them.
No, absolutely not.
I'm so sorry. I misunderstood the question.
My Lord was saying maybe there may just possibly be situations where the law is not completely clear at the outset. In fact, of course, in English law, that is very, very common.
Yes.
And we don't regard it as being so terrible. After all, most of the cases that come before the Supreme Court, the answer isn't clear because otherwise they wouldn't be before the Supreme Court. But supposing there could be an extreme case, that wouldn't deprive the court of its jurisdiction to decide the case as between the private parties.
Yes.
If one of those parties felt that his convention rights had been violated as a result of being made subject to law which was not sufficiently of the sufficient quality, foreseeability, accessibility, etc., well, then he could take the UK government to the Strasbourg court. But that would not affect the validity of the order made in the UK court or indeed in the Judicial Committee of the Privy Council. It would simply be a matter between that person and the government. That, I think, is the point that my Lord was making. And I suppose he was asking you to comment on it. I'm not entirely sure.
Well, I was just, I mean, in fact, I think we've come very close to saying that in some recent cases on costs, conditional fees, and we may also have said it in a competition law case.
Yes, you have. I failed the undergraduate test of not answering the question I was asked. I'm afraid I misunderstood the question I was asked, and I'm extremely sorry for that. And thank you very much to Lady Hale for having to translate for me. So I'm sorry about that.
Probably failed some sort of tutorial test.
But in any event, in relation to this case, the answer is in fact the same. Although it's a reverse scenario, my answer is the same, which is in theory, yes. In this case, we would be surprised if that was an appropriate course to take, but that obviously is not a matter for my client. It's a matter for
no, it's really an argument which Ms Derbyshire may come back on.
Yes.
Miss Wakefield, I'm afraid.
Sorry, Mr Wakefield, I do apologise.
But that's right. But the position, our position in relation to Article 1, Protocol 1, if I can summarise it, is, first, we say this doesn't arise in any event. Secondly, if we do have to satisfy the quality of law requirement, it plainly is satisfied. If you look at what's required in Sunday Times and the UK, Wingrove, the cases we've set out in our written case, we say there is sufficient accessibility and precision in this case. And we say also that those requirements are sensitive to the necessary flexibility of a common law jurisdiction, and they're also sensitive to smaller jurisdictions. So there's no requirement that a smaller jurisdiction with a population of 600 people must have live feed hearings like these, must have judgments uploaded to a website immediately afterwards. Indeed, the jurisdiction where I originally qualified, Ireland, still fails in many ways to provide judgments in that way. So there is no requirement whatsoever that you must have a system of justice which operates like the High Court of England and Wales or like the Supreme Court of the United Kingdom in order to satisfy the test. It is simply not correct. And as well as being sensitive to circumstances, the case law of the European Court of Human Rights also makes clear that it has regard to other matters, such as the importance of customary law, which is the point I was just going to. And all of those points mean that the quality of law requirement is in fact satisfied here, and this ground of appeal will be bound to fail in any event. But the ultimate fallback would indeed be, as you say, my Lord Mance, that even if there was something in this point, which we say there isn't,
it wouldn't affect you.
The real complaint, it shouldn't affect my client. It should be a complaint as between the appellant and the government, rather than as between the appellant and the respondent. And on that issue, we did start our submissions yesterday by referring to the urging in the courts below of the parties to try to step back from the procedural morass and to bear in mind that the parties have now been locked in almost continuous litigation over the future of this child for a period of half a decade. And if there were to be consideration given to the issue of whether or not to take the government to the European Court of Human Rights, I would very much hope that those words could be borne in mind, and as to where such a claim would be going and whether it's in fact going to help with the issues raised quite rightly by the Deputy Bailiff in the Royal Court and quite rightly by the Court of Appeal of Guernsey, that there is a child at the heart of this case. There's a child who has now had half a decade of his life taken up with this wrangle which has been ongoing, and it is an utterly unacceptable position to be in. And that is the basis, that's the background against which the Court of Appeal made the decision it did about special leave.
Ms Gallagher, I don't think that the board understands why this long-standing argument about money has had the effect of obstructing your client's application for leave to remove?
Yes, I'm afraid that to answer that question, it will be a matter of disputed fact. And I should say, in relation to that, there were some questions put yesterday and today about how much money my client's receiving, how much money the child is receiving, and the answers which were given are not accepted. But you are not being invited to decide matters of fact.
No.
You're being asked to decide matters of law. I think it's very unlikely that we will be able to reach agreement on the facts to explain the delay. Similarly, I think it's very unlikely that we're going to be able to reach agreement on the facts as to how much money this child is in fact receiving and how much money the mother is in fact receiving.
Well, is your client's
when he stopped
application for leave to remove listed for future hearing?
Currently, if you just give me a moment. So this may be disputed. I assume it won't be. There is no current listing date. If the board would be assisted by an expanded factual summary on some of those matters, we can of course try.
Well, it will be controversial.
Yes.
And so,
and it doesn't
from
go to
my
the
point
legal
of
issues
view,
which
I
are
think the
before.
answer is thank you, but no.
Yeah, I thought that may well be the answer. In summary, our position is that this is an unmeritorious claim, that ground 2 of 7 of the appeal should certainly have special leave refused, and you can't engage with these issues in a first instance way, and that on the other topics, the Court of Appeal of Guernsey, in difficult circumstances, got it right in its judgment, and we endorse its findings. We've added to it some points which we've made, which are additional to what it said. We think it got the decision right, and that this appeal should be dismissed.
Yes, we have that.
Yes.
Further to what my Lord Wilson is saying, we of course are not in a position to resolve any disputed issues of fact. Nevertheless, it would be of some assistance to us to have an agreed chronology of the progress of the litigation in relation to the care in the widest sense of this child.
We have those dates, and I think we should be able to reach agreement just in relation to the court dates.
And as to what the court dates are and what orders have been made.
I think the difficulty will be that if the board is inclined to be critical of delays and doesn't have the explanation as to whether there have
We're
been
not
some
going to be
delays.
critical of either party in relation to
Yes.
it,
No,
but we want to know what the situation is.
Yes. I mean, the end result is half a decade, and we're in the position that we are.
You're complaining about
Yes.
half a decade. Well, it's entirely possible that Miss Wakefield would complain about half a decade.
Yes, well, and indeed, both parties are agreed. Both parties have raised a concern about that timing in their case. And there's just 2 very short points, unless there's anything further I can assist with. In relation to, I didn't deal with the points because I started answering a question from Lord Mance on the Seneschal as a layman, and this not being a valid point. I didn't hear it being pursued particularly in oral submission, so it may not be necessary to trouble you. There's good reasons why that is not a valid reason for complaining.
Got a little bit
Quality
jumped
law
on
sense.
by me, I'm afraid, so...
Took the hint and shut up at that.
And the second point, just very briefly, I'm very grateful to Mr. Jacobs. For Blackstones, we can provide you with the extract if helpful. It's the first book, Introduction, Section 3, pages 63 to 69. And if it would be helpful to provide that, we can
to
give
the
it.
4th edition. What are you implying? It wasn't in the 1st edition, Miss Gallagher?
The 4th edition is the one that everybody usually cites.
Yes.
Is it?
Yes.
That's all. We can certainly trace the history of it. I think it was, in fact, in the first edition, but
I see. Very well.
we can, if it's helpful to provide it, we can do it. But I'm very conscious you've got rather a large amount of paperwork before you, and it may not be of assistance. Is there anything further I can assist with?
Could I give your learned junior one further task?
Yes, of course.
I have before me the 2nd edition of Ogier's book.
Yes.
And I cannot relate the pages that you have produced to this volume. I just wonder whether there's a possibility that while the covering page of Ogier's 2nd edition, you may have copied the 1st edition. I don't know. But if that could be checked out and let me know.
I'm afraid that document was provided by Blackstones rather than provided by us. But we can certainly obtain it
if you
and
could check it
We can
out,
do
because
that.
I think insofar as we refer to Ogier, we better get the pages right.
Yes, I'm sorry about that error. We did think it was going to be the 2nd edition. It looks as if it may be the wrong one. We'll obtain that. Should I send that through by email?
Well, I just wish to know whether you accept that the pages weren't the 2nd edition. I can make available to my colleagues the relevant pages from this book.
Better send it to the registry.
Thank you.
Yes.
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 If you send it to the registry.
Thank you very much.
Can I just ask something else, having set a hair running earlier with Miss Wakefield about what was being paid at what particular point, and trying to fix the date of the interim order? That was the 14th of August 2013, was it?
Yes.
And the order was at page 183 of volume 1 of the proceedings for £1,037 a month, am I right? Yes. I'm just trying to find some uncontroversial way of trying to run down the point. If we turn to page 140, I think that is what precedes the making of that order. And I think that...
I'm afraid it won't be the whole picture from the record.
No, it's just one passage. I think that is the transcript because of page 134.
Yes, it is.
Okay, so it's page 140, and it's what I think is being said by the advocate for the father, and it is an assertion as to what he's been paying.
It's an assertion as to what he's been paying.
I've understood the record
Yes,
correctly.
Yes, that's absolutely
Thank
right.
you very much.
I will see if we can get some agreement and reduce if those figures would be helpful. We'll see what we can do.
Well,
but it's more complex. We don't go into our version of it, but we don't accept the impression that's been given to the board.
No, but that's what he was saying was the position.
Yes.
Thank you.
Thank you very much.
Thank you very much. Do you follow? Thank you. Yes, Ms. Wakefield.
My lady, might I have overnight to prepare my reply as adverted to for my learned friend's submissions after lunch?
I would send it given to you 4 days, having to see everything now.
I mean, this is very, very unusual, Ms. Wakefield, but we understand that you did come into this. I'll try not to find an adjective for this case. Very late in the day and in difficult circumstances. We would not normally do this. We would normally say, do your best now, because that is what any other advocate appearing in this court has to do. We appreciate that you're not as familiar with this court as some other advocates are, although we have seen you before, and the difficulty of the position in which you find yourself. You may have half an hour and no more tomorrow morning.
I'm grateful. Thank you very much.
We'll adjourn now.